Okay, hopefully. Okay, good. Sound is working. Good, good. All right. This one is a long one. It's 65 pages. Each page is essential to me in understanding the reasoning of what happened or what decision the judge came to and why, and addressing each part of why the judge came to its decision. So, okay, this is important. This is important for employees and employers in understanding your responsibility on each side so you hmm, save yourself some time and money. All right, so I'm going to try to take my time. We're going to pace ourselves here. Hey, Paulette. Okay, this is back quick summary. This particular employee said that their performance fell because of depression. Depression is their disability that they're claiming. The issue at hand is that they're retroactively claiming it, but also trying to say that they did inform their employer and the employer did not do what they were supposed to do to make the reasonable accommodations. Okay. So, hey, Miss Queen Liz. So, we're going to go through these elements, and I really enjoyed reading this. So hopefully I can read it out loud and pace myself because there's so much in here. But the judge does a great job of laying out the reasoning for the summary judgment. All right. So here we go. And I'll be offering some opinions throughout just to break up the monotony on this one. So it says, currently pending before the court is the motion of for summary judgment of defendant the cellular connection, they go by TCC or defendant, filed on April 29th, 2025. On June 12th, 2025, plaintiff Joshua D. Pennell, or plaintiff, filed his brief in opposition of TCC's motion. On June 24th, 2025, TCC filed its reply in support of its motion, and for the following reasons, TCC's motion is granted. TCC would be the employer, Joshua Pennell would be the employee. So here are the undisputed material facts. In 1998, Pennell began experiencing symptoms of depression and sought the assistance of a therapist for his depressive mood. In 2007, he was diagnosed with clinical depression. His symptoms include intermittent intense fatigue, which is overwhelming at times, and his emotional state sometimes doesn't reflect the current situation that he's in. According to Pennell, his symptoms also include sleep disturbances, inability to awaken from sleep, and disorientation upon awaking, excessive daytime sleepiness, episodes of uncontrollable sadness and emotional upset, dizziness or lightheadedness, and compulsive eating. These symptoms, when active, affect his ability to concentrate, think, work, learn, and sleep. Okay. In 2017, Tom Sikora hired Pennell to be a regional manager for TCC, where he worked until TCC terminated his employment on May 2nd, 2023. Sikora was a dealer director for TCC and served as Pennell's direct supervisor throughout Pennell's tenure at TCC. Pennell was responsible for selling equipment to one dealer, Brian Delaney, who owned 35 retail Verizon locations. He also assisted with 20 additional locations outside his region owned by Delaney. According to TCC, regional managers were required to attend weekly team meetings. So these are your job position requirements. Attend the weekly team meeting, complete at least 16 store visit reports per month. However, Pennell testified that the minimum store visits was often subject to change, depending on situations happening within our region. Pennell also testified that frequently the 16 suggested minimum number was not obtained by myself and others. October 2019 is when Pennell disclosed his depression, or that's when he claims he disclosed his depression. Pennell claims that he first disclosed his diagnosis of depression to Sikora, his supervisor, on October 23rd, 2019. Pennell and Sikora were attending a 50-person meeting in Scottsdale, Arizona, to hear a presentation by a team from Motorola. During an intermission, Pennell sent Sikora a text message and asked to speak with him in the hallway privately. Pennell testified that during that discussion with Sikora, he presented to Sikora my emotional state, my diagnosis of depression, so that I could help him understand why I was experiencing the symptoms that I was at the time. And then I asked him if I could or if he would excuse me from part of that meeting because I was feeling this way. And I didn't think it was going to go away. I was in tears, sort of explaining this to him. I really had no choice other than to explain it. Now, intermittently, they present quotes from their deposition, and I'll be reading a lot of those quotes for context. And it says, according to Pinnell, Sikora acknowledged Pinnell's presentment of his emotional state and his diagnosis of depression and accommodated him by excusing him from the meeting, testifying that Sikora understood, obviously, as he could see what was happening, and excused me from the back half of that meeting so I could go be by myself and kind of let it pass. At another point during his deposition, Pinnell repeated that testimony. Question: you say you disclosed to your supervisor, Tom Sikora, on October 23rd, 2019, that you suffered from depression, correct? Pinnell answers, clinical depression, yes. Sikora disputes that Pinnell mentioned his depression to him on October 23rd, 2019. Instead, according to Sikora, Pinnell did not tell him why Pinnell was taking medication, and that the only thing that I remember is something about either Pinnell stopped taking medication or the medication needed adjusting. Pinnell and Sikora's 2021 through 2022 text message exchanges. Throughout 2021 and 2022, Pinnell and Sikora exchanged several text messages where Sikora accommodated Pinnell's request to miss certain work obligations. Those words are important. His supervisor accommodated him when he requested to miss work obligations. So here's some text message history. Pinnell, who is our plaintiff suing the employer, says, hey, Tom, I'm going to miss our call this morning. Was moving furniture yesterday and tweaked my back badly. I can't move at all, so I'm worried about this. I'll let you know what's happening as things change. Sikora responds, sorry to hear about the back, buddy. I canceled the call since I'm in meetings all week. So that was an accommodation. Sikora writes back, how's the back, buddy? Hope it's getting better. Pinnell says, miserable, not a smart move what I did. Sikora said, man, sorry to hear that, buddy. Advils and heating pad. Okay. Then we go to November 2021. Pinnell says, I'm heading over to pick up my kids from school. Someone has called in a bomb threat. Keep you posted. Sikora said, oh, wow. Hope everything is okay. This, of course, said, were you able to get the boys? So I'm assuming a lot of time passed. They didn't put timestamps on this part. Pinnell said, yes, thank you. Took a while to get them settled. All good now. January 25th, 2022. Pinnell says, one more sick day today, and I'll be out of the weeds here. I'll add to day force. Thanks, Tom. Sikora says, hope you feel better, buddy. Chicken soup and Gatorade. Take it easy. February 23rd, 2022. Pinnell says, hey, Tom, I have an appointment this morning at 10 that I can't reschedule. I'll send commitments shortly. My apologies. Sikora said, okay, I'll send you some notes for what we need to accomplish with your region this month. April 2022. Pinnell says, I've caught the Rona. Sikora says, sorry to hear, Josh. How are you feeling? Pinnell says, like hell, coughing and aches since yesterday morning. Super great timing, LOL. Sikora says, well, rest up and feel better. I'll let Johnny know you won't be making it to Orlando. May 20th, 2022. Pinnell says, I'm not feeling well this morning. Need to skip our call. Got my vaccination yesterday. Call you later. Sikora says, sounds good. Glad to hear you got your vaccination. Feel better. August 3rd, 2022. Pinnell's December 2022 failure to submit store visit reports. Okay. Oh, I guess I was reading that in the... Sorry, the dates came after each text message. I apologize. Okay, so next part is failure to submit store visit reports. And I think, yeah, it's going to go over it. We'll just go over it. Okay, it says on December 6th, 2022, TCC held a dealer team meeting in Tampa, Florida. The agenda for that meeting included a section on store visits and a sub-bullet that provides in relevant part 16 minimum per month. visit report needs sent out within 24 business hours of visit. Okay, that's the agenda. At this point, at December 6th, 2022, I feel like, okay, TCC put it out, so not just Sakura. Okay, I feel like this is where we're definitely setting a minimum. 16 minimum per month. So you have a objective at your job, right? Okay. And then it says you also have to submit your report within 24 business hours of the visit. Secor testified that the goal was to at least get to 16. During his deposition, Pinnell testified that from November 17th, 2022 through December 19th, 2022, so that's about a month, he submitted 0 store visit reports. Minimum 16. He testified he submitted 0. Pinnell testified that on December 19th, 2022, Sakura initiated a conversation during which Pinnell mentioned his depression. Okay, I'm going to take a break for just a second. Paula said he sounds off. He's being extra accommodating. Wow, where's the notes from the doctor? I will say this. Depending on the company, you don't have to provide a well, because we're talking about reasonable accommodation. So there's 2 different things going here. If it's just for those one-time acute things, you technically don't have to provide a doctor's note until you miss multiple days off at most places. But then also, where is the doctor's information? Because you are talking about the ADA reasonable accommodation as well. This is not just, oh, sick time. This lawsuit is not just about, oh, I just need the sick time. So good question, Paulette. I hope you hang in here with me because we're going to be here for a while. Because this actually does answer like all the questions. I was very impressed. Okay. So Sakura, what did it say? Pinnell testified that on December 19th, 2022, Sakura initiated a conversation during which Pinnell mentioned his depression. During this conversation, we did discuss, like he asked me what was going on, and I explained how I was feeling again, what the effects of my depression were, making me very tired, and that's when he made the suggestion that I take some time off at the end of December. Okay. Hey, Arhev. I'm glad you like it. Okay. And then Pinnell says, which I did. So he did take that time off. Question was, okay, he suggested taking time off. Pinnell said, yes. Question, how much time did you take? Pinnell said 1 week. Then it says, Pinnell testified that during that conversation, he asked Sakura, his supervisor, if he could apply his accrued time off for time that he had missed and recalled the following. So this is them asking Pinnell, when did you ask for leave? Pinnell says, I had used the system to request time off throughout my time at TCC, but I specifically asked for it in December of 2022. What did you specifically ask for in December of 2022? I asked Tom if I could use my accrued time off for time that I had missed. I want to clarify this now, although it gets clarified later. He still didn't specifically answer it, but what I feel like he was asking is that, can I use my newly accrued time off to retroactively cover my missed time in the past? That was his question, in my opinion. And I feel like it's going to get confirmed later, but there's so many timelines. I don't want to just be for sure about something I don't remember the timeline. And they said, and that was in December of 2022. Pinnell said, yes. What did Tom say? Pinnell said he didn't respond. This was a verbal conversation? Pinnell said yes. In person or on the phone? Pinnell said on the phone. Was anyone else on the call other than you and Tom? Pinnell said not that I know of. In December 2022, did you ask Tom for a specific period of time off? Pinnell said I did. What did you ask for? He said, I asked for the use of 2 days of my personal time or paid time off, rather. After that conversation, okay, and then we're done. That was the end of the quotes. And then it says, after that conversation on December 20th, 2022, Sakura issued Pinnell a corrective action for not timely completing and issuing store visit reports, which, remember, their requirements came out and says 16 minimum store visit. Goodness gracious. Choked on nothing, y'all. Okay. It says, per our conversation in April 2022, you needed to complete and send out store visit reports per the expectations in your role. We have not received a store visit form from you since November 17th, 2022. The expectation is that you send these out on a weekly, monthly basis to the appropriate individuals. If you do not send these out timely, as stated, you will be subject to further disciplinary action up to and including termination. Then it says the action required by employee included the following: 16 minimum store visits completed and sent out per month. The visit report needs to be emailed out within 24 business hours of the visit, sent to the owner, DM, your director, and Johnny. They give them the subject line. Then it says virtual visits can be used when necessary. Both Pinnell and Sequoia. Now, this man did zero. He could have done teams, and he didn't even do that for those 30 days. It says both Pinnell and Sikora signed the December 2022 corrective action. The parties do not dispute that Pinnell successfully completed his store visit reports following that corrective action. So for a little bit, he got better. That same day, Sikora emailed the December 2022 corrective action to Kimberly Miller, TCC's Director of Human Resources, because it's going to be documented. On December 21st, Miller emailed Sikora, the supervisor, did you still want to connect on your convo with Josh? So this is HR in their HR capacity asking the supervisor, do you still want to talk about Pinnell? Okay. On December 22nd, 2022, Sikora responded, yes, are you available this morning for a 15-minute call, say 10 a.m.? They had a phone conversation, and Miller testified that during that conversation, he let me know that when he issued the documentation to Josh, that Josh disclosed to him that he was going through a divorce. We talked about our EAP program, our employee assisted program, which would be a free confidential resource that Josh could use if he needed additional support. So Josh Pinnell is telling his supervisor, I'm going through it. I'm getting a divorce. It's not looking great, right? The supervisor does what he's supposed to do. Not he does a disciplinary action, but he does seek resources for him, and he offers them EAP, which is a great resource, really great. And then he said, that's what our she said that's what our conversation was about. When asked if Sikora told Miller that Pinnell had been battling with depression or that Pinnell takes medication for his depression, Miller answered no. So HR was not made aware by Sikora, who also said he honestly didn't know Josh was depressed at this time. He just knew he was on some type of medication. That was not a conversation they had between the supervisor and HR. All right. March 26th through the 28th, 2023, convention in Atlanta and the final written warning. TCC hosted a wireless zone convention at the Lowe's Hotel in Atlanta from Sunday, March 26th through Tuesday, March 28th. Pinnell testified that the commitment was to be at the conference Sunday, Monday, and Tuesday. That's a commitment. That's a work commitment. The following events occurred from that Sunday through Thursday, March 30th, 2023. So on Sunday, 7:13 a.m., on Sunday, the first day of the convention, Pinnell texted Sikora that he missed his flight. His flight was at 6 a.m. Pinnell texted his supervisor at 7:13 a.m. still in Cleveland. So he said it was because the weather knocked down the trees and power lines yesterday up here. My drive is blocked and power is still out. Can't believe it. Nobody hurt, but I missed my flight. Call you later. Later that morning, Sikora, the supervisor, texted him asking him if he was flying out of Cleveland, which Pinnell confirmed. And at 12:04 p.m., Pinnell texted that power is back and debris has been cleared. I can get out to the airport now. Lots of alternate flights. Keep you posted. Okay. But that evening, Pinnell texted Sikora and said his head was splitting, but that he would fly to Atlanta at 6 a.m. the next day. Now we're at Monday, March 27th. Pinnell flew to Atlanta the second day of the March 2023 convention. Pinnell testified that his task that day included being a guide to lunch and being a guide to a bus in the lobby at 6:15 p.m. He was supposed to guide people to the buses that would be taking convention attendees to the Painted Duck, a local restaurant. Pennell testified that he didn't do any of those things. He claims he forgot to be a guide during lunch and forgot about the 6:15 p.m. after hours event at the Painted Duck. Pennell testified that he began to experience extreme mental and physical exhaustion. So when the day's events ended at 2:15 p.m., he went right back to his hotel room. At 10:08 p.m., Sakura, the supervisor, texted Pennell, "Did you make it to the Painted Duck? We are playing duck pin bowling." Tuesday, March 28, 2023. Tuesday was the final day of the March 2023 convention. Oh, and let me just say this in case my brain does not tell me to go back to it. Pennell's job was to be the guide to the buses for them to get to the Painted Duck. I don't think he would have been in so much trouble if he just didn't also attend the event after hours at the Painted Duck, but he didn't guide the attendees to the Painted Duck, to the transportation that got them to the Painted Duck. That was his job, his actual job for that part of the day. Okay, March 28th, Tuesday. It was the final day of the convention. At 7:05 a.m., Pennell responded to Sakura's text message from the evening before, asking him if he had made it to the Painted Duck. This was last night. Now we're in the morning. It doesn't matter. He texts back in the morning, "No, I was exhausted by then and needed to lay down." At 10:42 a.m., during one of the convention events, Sakura texted Pennell, "Most of us are sitting near the back right corner. Where are you?" When Sakura had not heard back from Pennell, he called the front desk of the hotel to have the hotel staff perform a wellness check. The hotel staff woke Pennell around 11 a.m. So Pennell was sleeping. And I will reiterate this. Pennell is claiming clinical depression. That's what he's claiming. How this comes together is, again, so interesting to me. The hotel staff woke him up around 11 a.m. and Pennell texted Sakura back at 11:23 a.m. "I'm getting dressed." However, Pennell was too late and he testified that he did not attend any event that day. So he missed day one because the flights and the trees were down knocking around the road, and then he missed day 3. He got a little bit of day 2, but not all of his duties done in day 2. It says, later that day, Pennell left the Lowe's Hotel to return to Cleveland. Pennell admitting that because he had missed the day's events, he went to the airport to return home. Wednesday, March 29th, Sakura and Pennell had a phone conversation about Pennell's absences at the 2023 convention. Pennell testified that it was his impression that Sakura accused him of missing the Painted Duck event because he merely didn't feel like going. Pennell concedes that he slept right through it, obviously, but he asserts that Sakura didn't seem to either. Okay, they're saying it in the way he talked, so didn't seem to either didn't understand or didn't care what I explained after that. So the reason I fell asleep and missed it didn't seem important to him. Pennell testified concerning his recollection of the conversation as follows. Question. So have you told me everything about the March 29th phone call with Tom Sakura about what you said and what he said? Answer. I may have neglected to mention that I attached how I felt and my, with the extreme fatigue was related to my disability or depression. I'm not sure if I had mentioned that the first time. Question. Well, what did you say the fatigue was related? What specifically did you say the fatigue was related to? Your disability or your depression? Which one was it? Pennell said, well, depression, I said at the time. Yeah. And they said in the March 29th call, he said yes. Pennell said, and it was in an assumptive manner since he's talking about him and Sakura. I mean, we had talked about it before and I assumed he remembered. So I remember stating something to the effect of, we've talked, that we've talked about this before, that it's the same issue and that it wasn't caused by anything else but that. How did the call end? Pennell says the call in March after the conference, ? And they said, correct. Pennell said he was going to send over my disciplinary document to review and sign. So another disciplinary document. And they asked, and he did that? And Pennell said yes. It says later in the deposition, Pinnell elaborated on his recollection of the conversation. So, what were the other things that were discussed? Pinnell said, well, I tried to explain to him why I was so tired and what caused it, and that it was unavoidable for me. They asked him, and under action required by employee, it says it is expected to be on time and attend all sessions and events for any meetings, conventions, and all business functions. If there are or if there is a reason that will not let you attend any of the above, timely communication with adequate reasons is needed. Did I read that correctly? We're coming to timely a lot on this one. Pinnell said yes. They said, okay, and you understood all that? He said, I did. They said, okay. Pinnell said, although, I did not notify him as soon as I knew, and that, again, I reiterated to him that these symptoms and why I overslept and was so tired was caused by my disability. Pinnell claims, although Sikora denies, that Sikora said in an accusatory tone, are you depressed or are you tired? Pinnell testified that during the conversation, and as he had done in December 2022, he asked Sikora for time off, but it had already occurred. When asked to clarify this in his deposition, Pinnell confirmed, you weren't asking for any time off going forward? He said no. They said, what you were asking for was retroactively if you could apply a couple of PTO days to the time you missed at the conference. That's right. Here's the thing. That screamed to me for this case, you're trying to get out of trouble, because if all of a sudden they convert that to approved time off, then what you missed is okay because it's approved time off. So I would have been surprised had they said, yes, you can retroactively apply it to your days you were committed to be at the convention and you already used the money to fly out for it. All right. It says, after the conversation, Sikora issued Pinnell a final written warning titled March 30th, 2023, Final Written Warning. Like the December 20th, 2023 corrective action, and I think they meant 2022 corrective action possibly, but it included a description of the incident. It was communicated to Josh via email on March 15th, 2023, that one of his responsibilities, and Josh is Pinnell, that one of his responsibilities during the Wireless Zone convention was to be in the hotel lobby at 6:15 on Monday, March 27th, to guide people to the buses that would be taking us to the night event at the Painted Duck. Josh was a no-show for this responsibility. No-show and responsibility carry weight when you're getting disciplinary action. This also led to Josh not attending the convention's Monday night event at the Painted Duck. I texted Josh at 10:08 p.m. Monday, March 27th, asking if he made it to the Painted Duck. He responded on March 28th, Tuesday, at 7:05 a.m., no, I was exhausted by then and needed to lay down. Later, Tuesday morning, Josh was absent from the convention and breakout session. I texted Josh at 10:42 a.m. to let him know we were in the back right corner of the room and asked him where he was. Josh responded at 11:23 a.m. getting dressed. 11:23 a.m. They were already there and working, because they are working at that convention. That's the point. They had to be there. With the convention ending at 11:30. So he texted back, getting dressed at 11:23. The convention ended at 11:30. Josh was absent. There's absent again for Tuesday's breakouts and main sessions. Hey, Delicia. Then it says, it included the following action required by employee. It is expected to be on time and attend all session and events for any meetings, conventions, and all business functions. If there is a reason that will not let you attend any of the above, timely communication with adequate reasons is needed. Finally, although Pinnell did not include an employee comment in response to the December 20th, 2023 corrective action he received, Pinnell did provide an employee comment for the March 30th, 2023 final written warning that reads as follows. And again, I think they meant to put December 20th, 2022 on here. Excuse me 1 second. Okay. So this is what Pinnell put. He said, going forward, I will take care in attending all business functions or communicate ahead of time if I'm not able to. He said he will communicate ahead of time if he is not able to. He said, I did not plan ahead with the intention of avoiding convention events or tasks and responded to messages immediately once I read them. Travel complications over the previous 36 hours seemed to take a heavier toll on me than normal. According to our convention schedule, there was a 1+ hour remaining, including recap and closing remarks from 11:45 to 12:15, which I hoped to join but ended early. On March 30th, 2023, Pinnell signed his final written warning. On May 1st, he just signed this 2 months ago, right? On May 1st, it says they had a team meeting. May 2nd, it was termination time. Pinnell acknowledges that less than 5 weeks later, on May 1st, 2023, he fell asleep and missed a regularly scheduled 10 a.m. call with Sikora and his team. Sikora texted Pinnell at 9:59 a.m., "Are you getting on our team call?" but received no response. According to Sikora and Miller, after Pinnell missed the meeting, so the meeting's done, he and Miller talked over the phone and decided, and Miller is HR, talked over the phone and decided to fire Pinnell in the early afternoon. So then they're back to the deposition, asking, I think, Sikora, they're either asking Sikora or Miller, I can't tell which one, but what was discussed during that call? Answer, that Josh had missed a mandatory meeting and was already on a final, and then proceeded to send a text message later, like did not respond to Tom's initial text messages. He waited hours to respond to that text message, and when he did respond, he said he slept through his alarms. Right. You cannot plan ahead if you have depression, and that will be addressed. That's why this is so interesting, Paulette. You cannot plan ahead depressive episodes. So when I tell you, I feel like you will be fully satisfied with how this turned out once everything is broken down. I was. Hopefully you will be too. Okay, then it says, question, okay, anything else you discussed during that conversation? Answer, we did discuss next steps. Question, okay, and what next steps did you discuss? Hey, Glow. Answer, termination, because he was already on a final written warning for attendance. And it says, shortly before 1:47 p.m., Pinnell called Sikora, who declined the call and texted back, finishing a call you after. Pinnell then sent 5 identical texts to Sikora from 2:03 to 2:17 p.m. I stayed late working on my last few visits from April and slept through my alarms, with the exclamation mark. Still not having heard from Sikora at 4:18 p.m., Pinnell sent an email to Sikora writing, okay, this is what he wrote. Tom, wanted to let you know about the appointment I made to address some of the mental health challenges I've experienced, specifically over the past year or so. June 13th is the earliest I could get in and was scheduled back in February. I'm looking forward to discussing my symptoms with the doc and ultimately feeling better. This is where I'm going, and he gives a link to where he's going, and it says, thanks. At 5:54 p.m., Sikora sent the following email to HR, Miller. Let me know when you have time to chat about Josh Pinnell. Today, he missed my team call from 9:30 a.m. to 10:45 a.m. I texted him at 9:59 a.m. to see if he was getting on the call with no reply. He tried calling me at 1:47 p.m. while I was on a call, so I texted him I was on a call and would have to call him later. He texted me at 2:03 p.m. I stayed up late working on my last few visits from April and slept through my alarms. Please note that there were no visits sent out from Josh last night. He sent out 4 visits from last week today between 2:20 and 2:36. Most of the content of the visit reports had the same content with a few different points related to that specific location's visit. My point is that these visits would not have taken long to do the night before, and why wouldn't these have been sent out Sunday night if that is what he was working on? Later today, Josh emailed the attached email about making a doctor's appointment to address his mental health challenges. According to Sikora, this email was a recap email because he and Miller from HR had already determined to fire Pinnell during their phone conversation earlier in the afternoon. On May 2nd, 2023, Sikora and Miller fired Pinnell over a video phone call. So Sikora, the supervisor, and Miller HR were both on the video phone call with Pinnell. And Pinnell is the one that opened up this lawsuit against his company, saying that they did not provide him reasonable accommodation for his disability, which his disability he's claiming is depression. All right, so procedural history. All right, y'all, stay with me. Procedural history. Pennell filed his complaint on June 28, 2024. Therein, he asserts 5 claims against TCC. Disability perceived disability discrimination under the Americans with Disabilities Act. Count 1, disability perceived disability discrimination under Ohio. Count 2, failure to provide reasonable accommodation under the ADA. Count 3, failure to provide reasonable accommodation under Ohio. Count 4, and Family and Medical Leave Act, interference under the Family and Medical Leave Act. Count 5. Okay. On April 29th, 2025, TCC filed its motion. On June 12th, 2025, Pennell filed his opposition to their motion. The legal standard, summary judgment is proper. So they're setting up the court, the judge is the court, the judge, same thing. Now they're setting up their reasoning behind how they're ruling on if they'll make a summary judgment, and if they are, what the summary judgment is. So they have to make everybody understand the legal standard so you can understand their ruling when they do it. So they're saying summary judgment is proper if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. It says, thus, the mere existence of a scintilla of evidence in support of the plaintiff's position will be insufficient. There must be evidence on which the jury could reasonably find for the plaintiff. A fact is material only if its resolution might affect the outcome of the suit under the governing substantive law. At the summary judgment stage, a court should view the facts and draw all reasonable inferences in favor of the non-moving party. In addition, the moving party bears the initial burden of showing that there is no genuine dispute of material fact. I'm going down. The moving party may satisfy this initial burden by identifying those parts of the record which demonstrate the absence of any genuine issue of material fact. If the moving party seeks summary judgment on an issue for which it does not bear the burden of proof at trial, the moving party may also meet its initial burden by showing that there is an absence of evidence to support the non-moving party's case. Once the moving party satisfies its burden, the burden shifts to the non-moving party, who must then point to evidence that demonstrates that there is a genuine dispute of material fact for trial. From my understanding, the moving initially is going to be the plaintiff. The non-moving would be the defense, from my understanding. I will gladly be corrected if I'm misunderstanding. The non-moving party may not simply rely on its pleading, but must produce evidence that results in a conflict of material fact to be solved by a jury. Analysis. So we're on counts 1 and 2 of Pennell's claims of his disability discrimination. So Pennell asserts disability discrimination claims under those statutes. And it says the McDonnell-Douglas 3-step framework applies to Pennell's discrimination claims. And at the first step of the McDonnell-Douglas framework, the plaintiff must establish his prima facie case. I'm going to look this up because I have to say that a lot. Hold on one second, y'all. 1 second. Let me just look it up. Because if we're going to get through the rest of this, I meant to look it up and time got away from me. So 1 second. Let me see how I pronounce this. I haven't had to say it in a while. Prima fascia. Prima facie. That sounds more right. Prima facie. Okay. To establish the prima facie case for an ADA discrimination claim, the plaintiff must show that 1, he is actually disabled or regarded as having a disability. So he has to prove, I am disabled, or I would be regarded as being disabled. 2, he is otherwise qualified for the position with or without a reasonable accommodation. 3, he suffered adverse action. 4, his employer knew or had reason to know of his disability. And 5, his position remained open or he was replaced. At the second step, once the employee establishes a prima facie case of discrimination, the burden shifts to the employer to provide a legitimate, non-discriminatory reason for the adverse action, which in this case would be termination. Lastly, at step 3, if the employer meets its burden, the burden shifts back to the plaintiff to establish that the proffered reason for merely pretext for unlawful discrimination. In this case, the parties dispute only the fourth element of Pinnell's prima facie case, whether TCC knew or had reason to know of Pinnell's disability. All right, so it says TCC claims that Pinnell's theory of disability discrimination is that TCC had notice of his disability because Pinnell exhibited impairment in his ability to concentrate, think, learn, sleep, and work. But TCC did not have notice, it contends, because Pinnell never disclosed any specifics about his medical diagnosis, never submitted a treatment plan, never provided physician-imposed work restrictions, or otherwise submitted any medical documentation to TCC. TCC challenges 4 of Pinnell's assertions on which Pinnell relies to establish sufficient notice. In October 2019, Pinnell informed Sakura of his depression diagnosis. In December 2022, Pinnell informed Sakura of episodes of extreme fatigue. In February 2023, Pinnell informed Sakura that he had a medical appointment, and in March 2023, Pinnell told Sakura that his depression caused his fatigue. Okay, Pinnell's October 2019 disclosure of depression. One second, let me clear my throat. Okay. It says TCC argues that, I'm going to pronounce this Erdlika, established that a plaintiff's mere reference to depression without more is not sufficient to provide notice because it does not always rise to the level of a disability. And that Sakura allegedly responded to Pinnell by directing him to contact HR, but Pinnell never did so. In Pinnell's opposition, he responds that whether TCC was aware of Pinnell's disability is an issue of fact for the jury. Pinnell asserts that in October 2019, he specifically told Sakura that he was diagnosed with and suffered from depression and described to Sakura the severe symptoms caused by his depression and that he was on medication and under the care of a doctor. In TCC's reply, TCC reiterates that Pinnell's mere reference to depression did not provide notice under applicable Sixth Circuit law. So this is exactly when I got to this page, I was like, you need to be telling HR. That's what I was thinking the whole time. I get to this page, I'm like, why are you only telling your supervisor? Why are you not getting the paperwork to HR? This is reasonable accommodations go like, okay, it might go through a step with your supervisor, but you definitely, keep rounding up to HR. So I was thinking the same thing, Paulette, as I was reading this. Okay, it says, regarding these communications in its motion, TCC refutes that Pinnell's other alleged disclosures in December 2022, Feb 2023, and March 2023 constitute notice. TCC argues that notice was not provided by Pinnell's December 14, 2022 text to Sakura, Pinnell's February 2023 phone call to Sakura about his upcoming appointment, and Pinnell's March 2023 email to Sakura, embodied in Pinnell's employment comment in the March final warning about the effect of the toll of travel on him. TCC characterizes each communication as describing only routine symptoms of minor or short-term ailments, basically normal sick leave, that didn't, at best, that did not provide information from which Sakura could reasonably infer a disability. Nor does the ADA require employees to speculate on such matters. This is what TCC argued. In his opposition, Pinnell responds to each incident. As with his alleged October 2019 disclosure, Pinnell asserts that in December 2022, he specifically told Sakura that he was diagnosed with and suffered from depression and described to Sakura the severe symptoms caused by his depression and that he was on medication and under the care of a doctor. He also argues that TCC must have been on notice because Miller transmitted information to Sakura about TCC's EAP services upon Sakura's request after Pinnell and Sakura had their discussion on December 19th, 2022. Now, my brain said, he gave you those EAP resources because you said, I'm sorry, I'm going through it because I'm going through a divorce. So Okay. I don't want to be mean, but perhaps this isn't the right fit for him. You know what? You're on to something, Miss Queen Liz. I promise you, you're on to something. Okay. And then it says, Pinnell claims that his February 2023 telephone call to Sakura referenced not just an appointment, but also his worsening symptoms and medications. Pinnell attempts to situate his March 2023 email / employee comment in the context of other facts that allegedly indicate TCC was on notice, such as Sakura's request for a wellness check, which he had never done for another employee. Sakura making HR aware of the wellness check, Pinnell's reference to possible medical issues, and Miller's email indicating suspicion of something FMLA related, and Pinnell's May 1st, 2023, 4:18 p.m. email regarding his upcoming appointment mental health challenges to Sakura the day before TCC fired him. Additionally, Pinnell maintains that Sakura knew of his depression because he provided Pinnell information about the EAP and allowed Pinnell to take PTO in late December 2022. Pinnell concludes that because TCC disputes that Pinnell mentioned depression, a question of fact as to notice remains. Okay, so right now they're disputing question of fact, material fact. Did they or does this not constitute the notice part of the requirements? In TCC's reply, TCC reiterates its contention that the record only shows vague references or generalized symptoms rather than a treatment plan, physician-imposed work restrictions, or observable symptoms. TCC asserts that even if Pinnell had mentioned depression, that would not be enough to trigger TCC's duty under the ADA. According to TCC, Sakura's expressions of concern, i.e., allowing Pinnell to take PTO in late December 2022 and requesting the wellness at the convention, are merely vague assertions of concern which are not sufficient to provide notice. Lastly, TCC argues that Pinnell properly submitted notice at his subsequent job at a place called Radioactive. So they're like, he didn't submit the ADA reasonable accommodation stuff here, but he definitely did it at his following job the right way. So they're like, he knows how to submit the proper things. So now we're moving on. It says, viewing the facts and drawing all reasonable inferences in favor of Pinnell, the court, aka the judge, concludes, this is partial conclusion, we're going to get there, concludes that Pinnell has raised a genuine issue of material fact about whether TCC knew of Pinnell's diagnosis for and severe symptoms associated with his depression. The Sixth Circuit has recently set forth the following standard to assess when an employee has provided sufficient notice of his disability under the ADA to his employer. Although an employee is not required to use the word disabled to put his or her employer on notice, the employer still must know enough information about the employee's condition to conclude that he is disabled. Relevant information could include, among other things, a diagnosis. And y'all see, I highlighted that one because he said, at some point he disclosed his diagnosis, a treatment plan, which later I read, and we'll get there. The fact that he said he was on medication, I think they counted that as a treatment plan. Apparent severe symptoms, which would have been, I am very tired, things are becoming too much, all that. And physician imposed work restrictions. So out of those, I think the court said for him, he did disclose his diagnosis, the medication was the treatment plan, and the apparent severe symptoms were what he would put in his text messages and stuff like that. Okay. Then it said, and I was like, what, court? So but we'll keep reading. It says the employer is not required to speculate as to the extent of the employee's disability or the employee's need or desire for an accommodation. So the court is saying it can be argued that y'all were put on notice, but it is not the employer's responsibility to figure out, based on that, what accommodation do I provide? There is a formal process of applying for a reasonable accommodation. So then it says a general awareness of some symptoms is not enough to show that the defendant knew of the plaintiff's disability. It is true, as TCC points out, that neither an employee's mere mention of depression nor the employee's general awareness of some symptoms of depression are sufficient to establish that the employer was on notice that the employee is disabled. It says TCC cited Erlica and Hughes v. General Motors, where the employees asserted discrimination based on their depression, but the court in both cases affirmed summary judgment for the employer. But on this issue, the record here is different. It does not stand for the proposition for which TCC cites it. The court said, first, in Erlica, the court found notice lacking because the employee made only one unsubstantiated statement that she was depressed without any corroborating medical evidence and without ever having sought medical help. And she consistently presented the issue of her depression as a workplace conflict, not a disability. Therefore, quoting Katie, the court concluded that the employee failed to present any of the relevant information that this court has found pertinent to determining if an employer was placed on notice of a disability. So a lot of case law references for a reason, though. Let me see what y'all said. Medication was for the back. No, this was early. I know there's been a lot of reading. Okay, let me try to sum this up real fast. At some point, Pinnell argues he did tell his supervisor, I'm depressed, I'm on medication for it. Sakura said he never told me he was depressed. He just kept saying his doctor had him on medication for something. So that's where the medication came in when it comes to Pinnell. Now, these are about to get a little mixed up because we're also looking at case law that sets the precedent on how the court's going to rule for Pinnell and for TCC. But the medication for Pinnell is for the depression, not the not his back or anything. Okay. Can the candidate reasonably complete all job tasks and expectations outlined? It's not discrimination if something prevents them from executing core job functions, right? That's the thing. That will be addressed because it is discrimination if it can be reasonably accommodated for them to still be able to do a job, a core job or a core task. So that will be addressed because I'm like, when is it reasonable? When is it unreasonable? Okay. So then it says, the record shows that Pinnell claims that he met with Sakura and attributed his weeping to his diagnosis of depression, but Sakura denies that. Yet courts neither assess witness credibility nor weigh evidence at the summary judgment stage. It says, so this court cannot resolve whether it is Pinnell or Sakura who is accurately recalling whether Pinnell attributed his weeping to his depression at the business meeting on October 23rd, 2019. Instead, the court must view the facts and draw all reasonable inferences in favor of Pinnell. Now, when I read that, I was thinking, so he material fact, because unlike in Erlica, the record shows the relevant information referenced. Okay, I'm going down a little bit. But here, Pinnell provides enough to satisfy Katie's relevant information. He testified that he disclosed his diagnosis of depression to Sakura as an explanation for his ostensibly depressive episode at the business meeting in Scottsdale. I was in tears, sort of explaining this to Sakura, and at the same time, Sakura recalled that Pinnell disclosed that Pinnell was taking medication, which constitutes a treatment plan. Okay. Second, Hughes, which is one of the cases, is not helpful to TCC, the company. Not only is Hughes a non-binding, unpublished opinion predating Erlica's adoption of the standard from Katie, but Hughes was analyzing whether the employer was entitled to summary judgment on the employee's regarded as claim, which is a specific category of ADA discrimination claim, where the employee alleges that even if their disability does not actually substantially limit one or more of the major life activities, their disability under the ADA was instead simply being regarded as having such an impairment. So basically they're saying it's not relevant. That part of that TCC was citing is not relevant to the situation they're dealing with Pinnell. In the paragraph where the court in Hughes held that the employee failed to show she was disabled within the meaning of the ADA, the court cited Plant versus Morton, which explains the difference between a regarded as claim and a claim based on an actual impairment. Okay, let's get through this. Furthermore, we reject Plant's contention. We're reading a whole different case right now, another precedent setting. We reject Plant's contention that he was regarded as disabled within the meaning of 42 USC. Plant has come forward with no evidence to show that he fits within this definition of disabled, other than to suggest that because Morton made accommodations for Plant's medical restrictions, it viewed him as disabled. This is clearly not the kind of situation to which the statutory provision for those who are regarded as disabled was intended to refer. Rather, the EEOC regulations explain that this definition of disability applies when the employee has an impairment that is not substantially limiting but is treated as substantially limiting, or when the impairment is limiting only because of others' attitudes, or when the employee has no impairment at all but is viewed as having a substantially limiting impairment by the employer. The intent behind this provision, according to the EEOC, is to reach those cases in which myths, fears, and stereotypes affect the employer's treatment of an individual. Okay, so we're going to keep going. Let's see. Relying on the last sentence of that quote from Plant, the court in Hughes held that Hughes has not shown that GMC regarded her as having an impairment that substantially limits one or more of the major life activities. In fact, she puts forth no evidence that GMC regarded her as having any impairment. Hughes points to this evidence that GMC was aware of her depression. Another case with depression, different things going on there. She seems to assume that because of this, GMC regarded her as having a disability. A plaintiff cannot show that his employer regarded him as disabled merely by pointing to that portion of the record in which his supervisor admitted that he was aware of plaintiff's medical restrictions and modified plaintiff's responsibilities based on them. Okay, going down. GMC regarded her as having a disability does not speak to what facts are sufficient to put an employer on notice. We're back to the on notice part of an employee's disability in a non-regarded as text. Hughes stands for the proposition that the mere fact that the employer is aware of the employee's depression is not by itself sufficient to show that the employer regarded the employee as disabled within the meaning of the ADA, but not that the employer's awareness of the employee's depression is insufficient to put the employer on notice of the employee's disability. Mere awareness, in other words, may be insufficient to meet the regarded as definition necessary to succeed on a regarded as claim, and yet still sufficient to put an employer on notice, as Pinnell contends he did. That is true because an employer may be legally on notice that an employee is disabled, even if the employer does not in reality regard the employee as disabled. Therefore, viewing the facts in favor of Pinnell, just this section, TCC has sufficient information to conclude that Pinnell was disabled based on his depression because Sikora learned of Pinnell's diagnosis of depression and his medication-based treatment plan and observed his symptom of spontaneous weeping during a business meeting. Accordingly, the court concludes that Pinnell has established a prima facie case for his disability discrimination claim. Okay, this will bring it home. So he got the on notice part. Oh, yay. Okay. Hey, Mama V. Okay, it says, as noted above, once the employee establishes a prima facie case of discrimination, the burden shifts to the employer to provide a legitimate, non-discriminatory reason for the adverse action. So he established they were put on notice. Now the employer has to establish we did not fire you because we're discriminating against a disability you have. We fired you because you just weren't doing your job. Okay. So it says, as noted above, wait, did I already say that? Let me go down. TCC argues that it fired Pinnell not because of his depression, but because of Pinnell's repeated and well-documented performance and attendance deficiencies. Citing his failure to submit his 16 store visit reports for November 17th through December 19th, 2022. The fact that he was a no-call, no-show to nearly all of the March 2023 company convention, and his failure to attend the mandatory May 1st, 2023 team meeting at 10 a.m. without providing advanced notice after he signed the March 30th, 2023 final written warning where he definitely said he would provide advanced notice. Okay. It says, in his opposition, Pinnell responds that TCC's shifting reasons are pretextual because although TCC claims it fired Pinnell due to his excessive absenteeism, excessive is not defined in TCC's employee handbook, and TCC does not track attendance for salaried employees. And Sikora excused himself from previous team calls when he cited non-depression related reasons. So Pinnell's like, y'all don't have a number we have to hit to be absent to where it's like, okay, you fired me at this number because I was absent this many times, or y'all didn't define what excessive meant. That's his argument. Pinnell contests that his performance was deteriorating after the March 30th, 2023 final written warning because he remained in compliance with his store visit report requirement after failing to submit the reports in December 2022, maintains that the dealer he worked with, Delaney, did not complain of his lack of store visit reports, and contends that TCC failed to produce discovery evidence that shows that other regional managers successfully did submit their own store visit reports. So he's like, y'all didn't get on the other people if they didn't submit all their reports. The vendor didn't complain because I didn't come do the store visits. Y'all have to define excessive absences and all this stuff. It says that Pinnell asserts also amounts to a shifting explanation because TCC's original reason was his excessive absenteeism, not failing to conduct the store visits. Finally, he maintains that the testimonies of Sikora and Miller conflict with their email exchange the evening of May 1st, 2023, because Sikora's email does not give any indication that a decision to terminate had already been made and asked for further discussion about Pinnell. The one thing I will give him is that email because it says the way the email was worded, it seemed like it was the start of a conversation, not a follow-up conversation. It was dang it. Hopefully they'll quote it again, but the way they worded it was a little bit like, this don't sound like a follow-up. So that part could have been questioned, but I guess the judge didn't find enough reason to question that part. It says, in its reply, TCC replies that the March 30th, 2023 final written warning did not trigger Pinnell's termination, but was merely the first step in a progressive series of documented concerns. TCC notes that while excessive is not defined, Pinnell acknowledged in his deposition that attendance was mandatory. And according to TCC, Sikora's previous accommodations for Pinnell's previous non-disability related absences were made only if Sikora knew about it ahead of time. TCC also responded that it decided to terminate Pinnell before he sent his 2:03 to 2:17 p.m. text messages and his 4:18 p.m. email on May 1st, 2023, none of which referenced his depression or requested an accommodation. Although the parties do not clearly delineate which step of the McDonnell-Douglas framework they analyze, the court will first address whether TCC has set forth a legitimate, non-discriminatory basis for firing Pinnell, which is step 2, and then address whether TCC's proffered basis is merely pretextual, step 3. All right, so here it says, for the following reasons, the court concludes that TCC has met its burden under step 2 of the McDonnell-Douglas framework. So they're saying the company met its own burden on why they're saying they, should have their summary judgment and they did not discriminate against him and all that stuff. Okay, so it says Sixth Circuit precedent squarely establishes that unauthorized absences, excessive tardiness, and poor work performance are legitimate, non-discriminatory reasons for an adverse employment action. Here it is undisputed that part of Pinnell's job included submitting approximately 16 store visit reports per month, that Pinnell frequently failed to meet it, and that he did not submit any from November 17th to December 19th, 2022. Okay, going down. Accepting Pinnell's characterization of the 16 report threshold as a suggested minimum but not a mandatory requirement, the court finds that such a suggested minimum would therefore amount to a performance target or a goal, as Sikora alluded to in his deposition. So they asked him, was there, before December 2022, a meeting, another of, I hate how they're writing how they actually talk. was there before December 6, 2022, meeting a previous goal or minimum? And Sakura said, we felt like it was always right around that 16 number. Pinnell faults TCC for not producing evidence that TCC similarly disciplined other regional managers, but Pinnell did not produce any contrary evidence. So Pinnell said, hey, other people didn't meet their 16, but y'all didn't discipline them. The court said, you didn't bring any proof that this happened. You're just saying that. Okay, and it says, despite Pinnell's unsupported testimony that other regional managers did not meet the 16 store visit goal, he does not produce evidence in support of his supposition that he was treated any differently than other regional managers. That is insufficient to show that TCC's initial disciplinary action was discriminatory. Second, it is undisputed that Pinnell understood that he was required to attend the March 2023 convention. He missed the events on Sunday due to poor weather and attended most of the events during the day on Monday. I'm going down, I'm skipping the parentheses. He also conceded that less than 5 weeks later, on May 1st, 2023, he fell asleep and missed a regularly scheduled 10 a.m. call with Sakura and his team. Because poor performance and attendance are legitimate, non-discriminatory reasons for disciplining Pinnell, TCC has met its initial burden under the McDonnell-Douglas framework. For the following reasons, the court concludes that Pinnell has not met his burden to show that TCC's basis for firing him was pretextual. A plaintiff can show pretext in 3 ways: that the proffered reasons had no basis in fact, that the proffered reasons did not actually motivate the employer's action, or that they were insufficient to motivate the employer's actions. Pinnell relies on the second theory because he claims that a jury could conclude that once Sakura believed that Josh's depression and resulting symptoms would be chronic and more frequent, Sakura made the decision to terminate Josh rather than accommodate him. However, these are not the only ways that a plaintiff can establish pretext. These 3 categories are simply a convenient way of marshaling evidence and focusing it on the ultimate inquiry: did the employer fire the employee for the stated reason or not? Pinnell implausibly maintains that the court can infer Sakura's discriminatory motivation from the fact that Pinnell's performance did not deteriorate after December 22nd, 2022. Pinnell presents no evidence that Sakura was motivated by Pinnell's disability when he issued the corrective action, because it was obviously only after Pinnell failed to meet his performance expectations that Sakura attempted to correct his behavior. Pinnell claims he mentioned the effects of depression to Sakura, but Sakura responded by accommodating him, encouraging him to take time off at the end of December, not escalating the discipline in response to hearing about his depression. In other words, first Sakura initiated a disciplinary conversation based on Pinnell's performance issues. Then, when Pinnell revealed that his failure was caused by his depression, Sakura relaxed the discipline by giving Pinnell another chance to improve and encouragement to take a break. That is not enough to show that the corrective action was based on Pinnell's depression, but instead shows that it was based on Pinnell's lackluster performance. And I'm pretty sure that opinion came from the judge, this part about the lackluster performance. It says, Pinnell cites Fisher versus Nissan for the proposition that absences cannot be used to show that an employee is unqualified if the absenteeism is caused by an underlying failure to accommodate a disability. Pinnell misreads Fisher. The court in Fisher was not discussing whether termination for absences preventable by accommodation showed evidence of a pretextual basis, but rather whether absenteeism itself shows that the employee is unqualified. Yep, talking out the side of your mouth. The logic of Fisher is straightforward and uncontroversial. An employer cannot fail to accommodate an employee, then cite the employee's failure to perform unaccommodated to prove he was not qualified for the job. And this is a perfect example. It says, commenting that firing a wheelchair-bound teacher for failing to show up for class on the second floor of the school after denying his request for placement on the first floor could not be evidence that the teacher was not qualified to teach. Yet that logic has no relevance here, where TCC does not dispute that Pinnell was qualified for his role, but only that TCC offered a protectual basis for firing Pinnell based on his poor performance and repeated attendance failures. Pinnell conflates his underlying qualification for his position with his performance. Yes, you were qualified, but you did not perform well. But they are clearly not identical components of the McDonnell Douglas analysis, because an employee can be qualified for a job even if he subsequently fails to show up for work or underperforms in that job, as Pinnell has done here. Next, Pinnell accurately points to evidence that Sikora gladly accommodated non-depression related absences. Those include times when Pinnell had a bad reaction to a vaccine, hurt his back, was feeling like crap, had a general inability to sleep, or reported his need to reschedule an appointment. In every one of those instances, TCC explains that Pinnell gave advance notice, unlike the missing store visit reports from November to December. Pinnell's absences at the convention and missing the 10 a.m. meeting on May 1st, 2023. Rather than any evidence of a discriminatory motive, Sikora's positive reaction revealed in those text messages corroborates what Pinnell acknowledged in his deposition. And basically, they accommodated him. I'm gonna skip down because they're just reiterating that that's what they did. Thus, rather than establishing any discriminatory motives on behalf of Sikora, Pinnell's own testimony undisputably shows that Sikora accommodated Pinnell's absences when Pinnell gave Sikora advance notice, and that it was Pinnell's failure to do so on May 1st, 2023, and the previous instances that led to his termination. Lastly, Pinnell has failed to show evidence of a shifting pretext. They didn't change the reason they were going to fire him. Okay, I'm going down just a little bit. His failure to submit store visit reports, Pinnell conceded during his deposition, was because he sometimes did not reach the 16 visit number that was suggested. To the extent Pinnell was absent from the stores he was expected to visit in November and December because he did not achieve 16 minimum store visits completed, as noted on his corrective action, that too amounted to absenteeism. Indeed, he requested to use PTO to avoid discipline. That part is very important too. Trying to use PTO to avoid discipline. Okay. Pinnell emphasizes that on May 1st, Sikora sent his 5:54 p.m. email to Miller, HR, asking for when she had time to chat about Josh, and noting that in his 4:18 p.m. email, Pinnell had informed Sikora of Pinnell's upcoming doctor appointment. Yet both of them offer undisputed and corroborating, not conflicting testimony that they had spoken prior to Miller's 4:18 p.m. email. Sikora and Miller both offered consistent testimony that they had already decided to fire Pinnell before Sikora received Pinnell's 4:18 p.m. email, and that the 5:54 p.m. email served as a recap of the conversation they had before Sikora's receipt of the 4:18 email. All right, and then they reiterate their deposition when they ask those questions. I'm going down. Thus, the uncontroverted testimony from the two participants in that discussion demonstrates that Sikora's email on May 1st was simply a recap of the conversation they already had, which they had decided to terminate Pinnell. Pinnell offers no evidence to rebut the testimonies of Sikora and Miller on this issue and has no personal knowledge concerning the conversation between Sikora and Miller. Going down. Okay, so they said, accordingly, for the reasons set forth above, for the reasons set forth above, the court concludes that Pinnell has met his burden under step 1 of the McDonnell Douglas framework. TCC has met its burden under step 2, but Pinnell has failed to raise a genuine issue of material fact that TCC's proffered basis for firing Pinnell was merely pretext for discrimination based on his disability. Therefore, TCC is entitled to judgment on counts 1 and 2. So 1 and 2 are done in TCC's favor. Failure to provide reasonable accommodation claims. TCC argues that Pinnell never requested an accommodation for his disability. Pinnell does not identify any instance where Pinnell requested leave and TCC denied such request. TCC also argues that although TCC denied Pinnell's March 2023 request to retroactively apply his available PTO to cover his absences at the convention, TCC had no obligation to approve such a request because the ADA only requires prospective accommodations. Going on. In his opposition, Pinnell argues that TCC's knowledge of Pinnell's disability and his need for accommodation triggered TCC's obligation to engage in an interactive process even without an express request. Okay, that is a huge trigger phrase, engage in an interactive process, because employers are expected to do so under the law when it applies. Okay, I'm going down. Pinnell claims that TCC failed to discuss an accommodation with Pinnell before it terminated him on May 2nd, 2023. In his reply, TCC responds that the ADA requires the employee to explain that the request is being made because of their disability, and Pinnell did not provide any such explanation. Pinnell never applied for leave, did not have a history of taking leave to manage his disability, never submitted any documentation from his treating physician, and never advised TCC that he had a condition that might require future absences, let alone emergency leave. And TCC argues that the other cases Pinnell cites are distinguishable because in each of those cases, the employee's request for leave was more specific and the employee took more proactive steps to communicate their condition. As a threshold matter, the court must clarify the applicable legal framework through which to assess Pinnell's failure to provide reasonable accommodation claims. The court interprets Pinnell's opposition as resting his legal theory on TCC's alleged failure to engage in the required interactive process. As Pinnell notes, to establish a prima facie claim for failure to accommodate, a plaintiff must show that he was disabled within the meaning of the statute, he was otherwise qualified for his position with or without reasonable accommodation, the defendant knew or had reason to know about his disability, he requested an accommodation, and the defendant failed to provide the necessary accommodation. Pinnell then links that framework to his failure to engage in an interactive process theory of liability, writing that, as discussed above, as to element 3, it is a question for the jury as to whether TCC knew or had reason to know of his disability. As to elements 4 and 5, employers are required to engage in an interactive process with employees to identify and implement appropriate reasonable accommodations. The court had already found that there is a genuine dispute of material fact as to whether Pinnell provided notice to TCC. The court agrees with Pinnell that only elements 4 and 5 remain at issue. From there, however, Pinnell appears to mistakenly assume, citing to Smith, that the interactive process is triggered by a request for accommodation or by the employer's recognition of the need for accommodation. In other words, Pinnell claims he satisfies elements 4, making a request for an accommodation and failing to provide it because Pinnell triggered TCC's duty to engage in the interactive process when it recognized his need for accommodation. But TCC failed to engage in that process. That's what he claims. The court cannot accept Pinnell's framework. Framing the triggering condition for the duty to engage in an interactive process as Pinnell does ignores the requirement repeatedly explained by the Sixth Circuit, as set forth below, that the employee must make a request. The employee must actually make a request for reasonable accommodations. They have to actually ask for the accommodations. Actually, like his next job, I think it was after this job, the one that they fired him from, I think now he's made a reasonable accommodation request at the new job. he seemed to have learned from this one. Okay, let's see. I'm going down. I'm going to summarize some of this. Okay, so this is a case, right? Smith tried to request, this is for accounting or something. They tried to make a reasonable accommodation request, or actual request, that because they had arthritis, that there's like 2 people below them, that maybe they could do some of their duties so they wouldn't have to stay at work so long. But I'm going to go down. I think they came out to the fact that it was not reasonable to ask for that one. Um, so let me see. It says, oh, see, I don't want to skip so much that I missed the point. Hold on. Okay, let me just read this part. It says Smith stands for the proposition that sending a letter requesting permission to delegate certain job functions is a request for a reasonable accommodation, and that such a request triggered the defendant's obligation to participate in good faith in an interactive process, which, yes, since they asked for that reasonable accommodation, their employer had to participate in the interactive process. Does not mean they have to approve it, does not mean they have to do exactly what you asked for, but they have to now come to some middle ground of what is reasonable to accommodate you and your disability. Okay, I'm going down. Hold on. Okay. So it says in Tenniel versus United Parcel Service, the court likewise wrote that to make out a claim for the denial of a reasonable accommodation, an employee must first show that he proposed an accommodation and that the desired accommodation is objectively reasonable. So it still has to be reasonable if you have a disability. Okay, it says, admittedly, in King, the court set forth its standard without using the word reasonable. Once an employee requests an accommodation, the employer has a duty to engage in the process to try to determine whether the employer can accommodate the employee's disability. And the court in King underscored that an employee's initial request does not need to identify the perfect accommodation from the start because it's an ongoing interactive process. Based on that authority to determine whether TCC violated its duty to engage in the interactive process with Pinnell, the court must determine whether Pinnell triggered that duty by analyzing whether Pinnell actually requested an accommodation, and if so, whether Pinnell requested a reasonable accommodation. Regarding the first requirement, the Sixth Circuit's standard in King sets forth what qualifies as a request under the ADA. The employee bears the initial burden of requesting an accommodation. They have to actually request an accommodation. It can be in different words, but it says we have generally given plaintiffs some flexibility in how they request an accommodation. Just as an employee does not need to use magic words to inform her employer that she is disabled, the employee does not need to explicitly use the word accommodation. A plaintiff's, hold on, medical documentation is not required. A plaintiff's own request, whether written or oral, can satisfy this element. However, the second requirement that the accommodation requested itself be reasonable requires more. The parties here dispute whether Pinnell's request for a retroactive accommodation was reasonable. Pinnell is correct that King recognized that not all requests for retroactive accommodations are unreasonable, but the court in King was careful to limit that holding to factual predicates entirely absent from Pinnell's case. So this part I can summarize. King was a nurse. As y'all can see, she had asthma flare-ups. They happened. They happened obviously unpredictably. She would call in sick until she could get approved for the more lengthy leave. But they kept delaying. But her job had a program where when they find like it made that you qualify for it, they would retroactively backdate your PTO to approve PTO for those days, even if they already happened in the past. Um, and they told her she didn't work enough hours to retroactively request those hours at first. But to come to find out, they had done bad math. She did have that time saved to where she could apply that time in the past, but they waited so long. They ended up, instead of just fixing their error, they fired King, which is why now they have a lawsuit with King versus her company, which is what they're relying on now as some of the precedents. Um, so she had notified three people: Burns, Bungard, the administrator, and nobody was getting back to her. And it says they still fired her that day for failure to apply timely for leave of absence, but she had applied timely. She was applying as it was happening as much as she could. And then it says, hold on, I'm going down. her physician was sending documents that she did have a chronic health condition. Proper documentation was coming through. Um, let's see. I'm going down because I'm trying to summarize some of it for y'all because I know it gets very like very, Okay, so it says the court noted that medical leave can constitute a reasonable accommodation and noted three considerations for assessing the reasonableness of the leave request: the amount of leave sought, whether the requested leave generally complies with the employer's leave policies, and the nature of the employee's prognosis, treatment, and likelihood of recovery. As to the first consideration, the court noted that the record contained many disputes about how much leave King sought, but that by June 5th, 2017, she asked for a set amount of leave to cover her absences. And then applying the second consideration, the court explained that under those circumstances, the record supported King's position that retroactively granted her emergency leave that can be used for a reasonable accommodation, and requests for retroactive leave are not per se unreasonable in King's position. Okay. Um, she also tried to tell her on-call supervisor she was actively trying to get leave, but it hadn't gotten yet, so she was reporting off again for the next day. So that was advance notice. The distinctions between Pinnell's request to retroactively use accrued PTO to avoid discipline. Avoid discipline is the key phrase for him on December 20th, 2022 and March 29th, 2023, and King's 14 requests for medical leave are substantial. So they're saying the distinctions are substantial between those two cases. First and most importantly, the employer and King had policies in place to handle these types of requests, including relaxed notice requirements for emergency leave requests and a 5-day look-back period for retroactive requests. Pinnell has not argued, and the record does not reflect, that TCC has any look-back period for retroactive requests for PTO or the application of PTO to avoid discipline. And for the same reason, the employee's failure to accommodate claim in Crispell is distinguishable from Pinnell's because there, the employee's retroactive request to be excused from the call-in rule when her symptoms prevented compliance simply represented a reasonable request to participate in the employer's typical procedures. Crispell, she also had already been submitting documentation. Every time it would say, I cannot be present due to this prognosis or diagnosis, and it is basically part of my reasonable accommodation. Like, she was very always attributed it back to the disability, back to the reasonable accommodation that was agreed upon, stuff like that. And they said King, going back to the nurse, cannot be faulted for the lengthy application process when the hospital, through the agent it hired to process leave requests, caused the delays. They punished King for it. It wasn't her fault. She submitted valid requests. Okay. Again, Pinnell does not suggest that anything TCC did or refrained from doing contributed to his inability to timely request PTO. He was just sleeping in. I mean, I'm not saying he didn't have an issue, but he had slept in and he'd say something hours later the next day. Okay, going down from King. Okay, it says, but when those circumstances are not present, as in this case, EEOC guidance and applicable Sixth Court precedent demonstrate that rescinding discipline is not a reasonable accommodation under the ADA because the timing of the request is crucial. If you already started getting in work, you have already run against the clock to try to claim reasonable accommodation to cover you getting in work before you applied for reasonable accommodation. If you have a disability, you need to be working on that reasonable accommodation ASAP. Because now it just looks like you're trying to, for Pinnell's position, you're just trying to get out of being in trouble. It does not just erase disciplinary stuff. It says there the employee argued that a leave of absence. Oh, sorry. Yarberry is instructive. There the employee argued that a leave of absence to seek treatment was a reasonable accommodation, and the employer contended that the employee could not rely on his disability and request an accommodation after engaging in terminable misconduct. Had Yarberry not already engaged in misconduct meriting termination, I'm just making up words, meriting termination, it is possible that his request for time off due to his hospitalization might have been timely, and I'm going to say Greg would have been obliged to try to accommodate him. However, because Yarberry had already committed the misconduct that Greg cited as the reason for his termination, Greg was not obligated to rescind Yarberry's termination or engage in further discussion of his request for accommodation. That one is very, very close to what Pinnell's going through now. Every time it seemed like he would panic when he realized he went too far and be like, let me send messages about my medical condition. Right, it does. Her case did make him look like really irresponsible, Paulette. Right? Okay, let's see here. Okay, so this person has sleep apnea. So it says during a discussion investigating his violations of the employer's policies, the employee allegedly said, "I've got something wrong. I've got sleep apnea. I'm falling asleep all the time," and explained that he had fallen asleep at work and in his car driving home and was scared to death of this. The court emphasized that his statements came in the context of his defending against the allegations of misconduct and explaining why he was observed napping. The court explained that even if the discussion with the employer were a request, it likely came too late to be considered reasonable, because when an employee requests an accommodation for the first time, only after it becomes clear that an adverse employment action is imminent, such a request can be too little too late. That's like the core of this lawsuit to me. When you realize you're in trouble, it is not the time that you're like, let me get that reasonable accommodation to try to erase the disciplinary action. You need to already just be trying to get the reasonable accommodation to handle your disability. And it says, let's see, EEOC guidance bolsters the prospectivity requirements set forth in Yarberry and Parsons. First, a reasonable accommodation is always prospective, so an employer is not required to excuse past misconduct, even if it is the result of the individual's disability. So when you're applying for your reasonable accommodation, it is for things that are possible to happen in the future. It's not to backtrack to what has already happened. So for anybody that's still out there in the working world, you need to understand that. Based on this guidance, rescinding discipline is not a reasonable accommodation. Okay. It says, quoting the above EEOC guidance and holding that Messenheimer has provided no evidence that she asked for an accommodation prior to her demotion for either of her alleged limitations, vertigo and hearing loss, and she has thus failed to make out a prima facie case for failure to accommodate. So over and over, the judge is citing case law to prove her point of why she's making this judgment. The employer did not fail to provide a reasonable accommodation because the accommodation the employee requested, i.e., that the final warning be removed from his employment record, is not one which was required to make. Numerous courts have held that an employer may impose discipline for workplace violations on an individual with a disability, and that a reasonable accommodation does not include foregoing or rescinding such discipline. Right, just like the song. Yeah, warning to his new job, like seriously. Okay. Although the ADA does not require employees to ask for an accommodation at a specific time, the timing of a request for a reasonable accommodation is important because an employer does not have to rescind discipline, including termination, warranted by misconduct. So again, it's another case. Schock versus Webster. Had Schock not already engaged in terminable misconduct, his request for an ASL interpreter at the termination meeting would have been timely, and Webster might have been legally obligated to try to accommodate him. So again, even asking for the ASL interpreter, I don't know what he did to get to the termination. Do it once you're about to be fired. Okay. It says employers may also impose disciplinary action for attendance problems that occurred prior to requests for reasonable accommodation. So it says, with the above principles and guidance serving as a backdrop and for the reasons more fully explained below, the court rejects. Uh, mm-mm. Okay, so it says, although Pinnell requested an accommodation from Sikora to use his PTO to avoid discipline, that request was not reasonable. He was already there with the discipline. It was too late. Okay, and then we kind of went over this. I'm going down. It says here Pinnell admits that he only requested accommodations to retroactively rescind his discipline, not to prospectively seek an accommodation from TCC. And y'all saw where the ADA is very clear about you have to be asking for future accommodations, not trying to retroactively fix discipline. Wait, what did I say? Trend? What did I say? What did I do? Am I still here? Let me know what I said. What did I do, Paulette? Okay. He says he also tried to get it rescinded for his final written warning. Again, you cannot do that. It has to be prospective accommodation. So it failed to trigger TCC's duty to engage in an interactive process on both times with his discipline. And it says, finally, the text and email Pinnell sent to Sikora were not requests for an accommodation. The law is clear that the employee must request a reasonable accommodation to trigger the employer's duty to engage in the interactive process. The above communications do not even request an accommodation, let alone a reasonable accommodation. And did they quote his text up here? Let me see. Okay, yeah, this was some of the text that he sent. He said he stayed late working on my last few visits from April and slept through my alarms. That does not contain a reasonable accommodation request. Wanted to let you know about the appointment I made to address some of the mental health challenges I've experienced, specifically over the past year or so. That is not asking for a reasonable accommodation. It's just kind of just informing them what's going on. And it says Pinnell does not request that TCC do or refrain from doing anything. Therefore, Pinnell did not request an accommodation. The flexibility King standard allows for employees in how they request an accommodation does not absolve the employee of the basic requirement of still making some form of a request. Therefore, these communications also did not request a reasonable accommodation, so these communications did not trigger TCC's duty to engage in the interactive process. Therefore, TCC is entitled to judgment on counts 3 and 4. And then we have FMLA claim, count 5, which I think is the last count. We're done. We're almost out of here. Okay. So he's saying that they should have given him FMLA, okay, because the HR Miller did mention FMLA in one of her emails regarding him. Again, I say this is when they were talking about EAP. He was going through a divorce. They can, confidentially give him counseling or whatever else so many things EAP will do for the employees. Okay. So it says they only dispute the fourth element, whether Pinnell gave TCC sufficient notice of his intent to take FMLA leave. TCC argues Pinnell never requested FMLA leave or discussed it with TCC at all. Pinnell says that he's not required to discuss FMLA leave. It doesn't require the employee to mention it when giving notice of intent to take FMLA leave. If the employer acquires knowledge that an employee's leave may be for an FMLA qualifying reason, the employer must notify the employee of the employee's eligibility to take FMLA. So if he had to name something that fell in that category, TCC's responsibility is to be like, okay, that qualifies for FMLA. Are you taking that? That's what he's saying they should have done. So, according to Pinnell, no one advised Josh of his rights under the FMLA. Had the FMLA leave been applied retroactively to cover his absences in March and on May, he asserts it would have constituted FMLA interference for TCC to terminate him for his absences. TCC pointed out that FMLA's policy, that Pinnell knew of FMLA's policy but did not avail himself of its provisions. Pinnell only made vague statements akin to feeling depressed or having a mental thing. Pinnell never submitted medical documentation to support his absences. For the reasons below, the court finds that there is no genuine issue of material fact that Pinnell failed to provide the requisite notice mandated. There were no unusual circumstances within the meaning of 29 CFR 825.303C excusing his failure to do so. It says the critical test for substantively sufficient notice is whether the information that the employee conveyed to the employer was reasonably adequate to apprise the employer of the employee's request to take leave for a serious health condition that rendered him unable to perform his job. I'm fading out again. Oh man. Hopefully I can get through this. I got a little bit left. Can I get a sound check? Let me know how bad it is. Hopefully it's not bad. I have like a last man, I'm down to the last pages. I promise I'm almost done. Less than 10 pages. It says that that is okay, hold on. That is because FMLA regulations make it the employer's responsibility to tell the employee that an absence will be considered FMLA leave. Okay. The Sixth Circuit explained there are two different notices requirements for FMLA, foreseeable or unforeseeable. I'm going to stick to unforeseeable because that's what his would have been. Okay, thank you. Thank you, Miss Clean Liz. Because my mic does act up sometimes. So we're only focusing on unforeseeable because that's what Pinnell's would have been. Okay, it says employees with known health conditions that result in a sudden acute flare up of symptoms must follow the 825.303 when requesting leave. That makes the leave unforeseeable and makes 303 the applicable notice regulation. I'm only going to read the highlighted parts for this part, but it says when the need for leave is not foreseeable, an employee must, okay, I'm reading unhighlighted too, must comply with the employer's usual and customary notice and procedural requirements. However, if an employee requires emergency medical treatment, he or she would not be required to follow the call-in procedure until his or her condition is stabilized and he or she has access to and is able to use a phone. If an employee does not comply with the employer's usual notice and procedural requirements and no unusual circumstances justify the failure to comply, FMLA protected leave may be delayed or denied. In other words, even if leave is unforeseeable, an employee must comply with the employer's usual and customary notice and procedural requirements for requesting leave absent unusual circumstances. So had he gotten what was defined as unusual circumstances, it would be okay for him to retroactively be like, I couldn't get to y'all in time to tell you I had the emergency because I was going through the emergency, the unforeseen thing. The FMLA does not excuse employees from complying with an employer's reasonable notice requirements. TCC's handbook mirrors that reg we just looked at. TCC does not dispute that Pinnell's depression is his FMLA qualifying reason, only whether he provided proper notice. Pinnell was required to comply with TCC's usual and customary notice and procedural requirements unless his depression, i.e., his FMLA qualifying reason, caused an unusual circumstance which would have excused such notice. Okay, TCC also has a handbook and they have a section titled Time Away from Work. And then it says it's a bolded subsection titled Family and Medical Leave Act. And then under that, there's a subsection called Procedure for Requesting FMLA Leave. Then it says all employees requesting FMLA must provide verbal or written notice to the Human Resources Department. FMLA definitely, I thought, would go through human resources as well. It is undisputed that Pinnell read the FMLA section of TCC's handbook. And in the deposition, he said yes. So that's why they're saying it's undisputed. But never contacted HR about his disability, health condition, or medical condition. He at least had, from the time he realized, oh, this is affecting me so much, I'm being put on the first disciplinary action. I need to go ahead and do that EAP. I need to get my reasonable accommodation together. I need to contact HR. But he just text his first line supervisor. Then he gets in trouble with the final. It's titled Final Issue. And he still messes up and tries to only text the supervisor and still has not, gone to those next steps to get the reasonable accommodation, which it looks like, you can be accommodated for going through clinical depression. You just have to go through the proper procedures. Okay, so he never contacted HR. Then it says because Pinnell did not comply with the usual and customary notice and procedural requirements, the viability of Pinnell's claim necessarily depends on whether his depression caused an unusual circumstance. Because if so, as noted above, that would have excused his compliance with TCC's notice requirement. Okay, so we're going back to this case about Crispell, and we are 3 pages away from the end, so I promise it's not going to take long. Crispell suffered from major depression, mood swings, and anxiety, which qualified her to take leave through FMLA. So we have case law. We're good. It says she worked at FCA until 2018, and beginning in 2012, in support of her FMLA leave request, Crispell's psychiatrist, Dr. Leon Rubenfire, submitted annual reports to CFA explaining Crispell's condition. In those reports, Dr. Rubenfire explained that Crispell's symptoms would incapacitate her on an intermittent basis. FCA issued progressive discipline to and ultimately terminated Crispell for failing to provide advance notice that she would be absent from work. But Crispell had been submitting letters after each late call-in that specifically cited her covered illness as the reason that she should not be penalized. The letters Crispell submitted after each tardy also complied with her initial burden under that 303 notice for FMLA leave. The court reasoned because they specifically referenced either the qualifying reason or the need for FMLA leave. The court held that those post-absence letters, so she's doing this retroactively. She's already gone through her episodes. She can't predict the episodes. This is what we talked about Paulette and Miss Queen Liz when y'all first came on. She is in the case of she could not predict her episodes. But every time the episodes ended, she is presenting her post-absence letters, and it created a genuine dispute of material fact about whether Crispell's failure to call in advance of her tardies was due to unusual circumstances within the meaning of the .303C, and reversed the district court's grant of summary judgment. So she won her case. Here, however, Pennell has not submitted even one, let alone 6 physician reports that he will become intermittently incapacitated. All right. So it says he certified that he had the ability to and would provide advance notice ahead of absences when he signed the March 29, 2023 corrective action. Quote, going forward, I will take care in attending all business functions or communicate ahead of time if I'm not able. That stands in stark contrast to Crispell, who had a physician certify that she could not always communicate ahead of time due to her disability. The example provided in the text bolsters the conclusion that Pennell had shown no unusual circumstance justifying his failure to provide advance notice. It refers to an employee who requires emergency medical treatment who would not be required to follow the call-in procedure until his or her condition is stabilized. Okay, and then they go through the definition of emergency as defined by Black's Law Dictionary. Pennell never suggests that he required emergency medical treatment or that his condition was so destabilizing that he could not use his cell phone. His failure to point to any depression-related need for emergency medical treatment or depression-related inability to use his cell phone places him far outside the unusual circumstances necessary to justify his failure to provide advance notice to TCC. Okay. So one other example they provided was a case, I think this is Ortega, no, who is this? Medley versus County of Montgomery. She had a son with Asperger's. 1 to 2 times per week and for up to 3 hours each time, her son would experience panic attacks inclusive of crying, hiding in the closet, covering his ears to block out stimuli, verbalizing his concern his mother will die, and clinging to his mother. And he began having anxiety attacks in which he would lock himself in a closet, hit and scratch himself, refuse to talk, and attempt to hurt himself. So she could not obviously provide advance notice. Basically, another one that clearly shows unusual circumstances. And it says Pennell's May 1st, 2023 text to Sakura did not reference a depression-related emergency similar to those incidents, but instead he attributed his failure to provide advance notice or make their 10 a.m. meeting to his having stayed up late working the night before. Quote, I stayed up late working on my last few visits from April and slept through my alarms. The court finds that Pennell's procrastination in waiting to submit his store visits reports until the evening of April 30th does not constitute such an unusual circumstance akin to an emergency within the meaning of the reg that we kept referencing. Having failed to show unusual circumstances, Pinnell was required to follow the usual and customary notice and procedural requirements to properly give notice of his intent to take FMLA benefits. But he did not do that. Therefore, TCC did not interfere with Pinnell's right to leave under the FMLA, even though it did not notify Pinnell of his right to take FMLA leave, because TCC did not acquire knowledge that Pinnell's leave may be for an FMLA qualifying reason. Accordingly, for the reasons set forth above, TCC is entitled to judgment on count 5. For the reasons set forth above, TCC's motion is granted. It is so ordered. December 9th, 2025. We made it through. We made it through, y'all. I hope they brought it together at the end, because for me, once I got through all those cases, I was like, oh yeah, this makes sense. They're not over here bullying this man because he has depression. He was just not doing his stuff right at all. Right. They sounded disrespectful, Paulette. She definitely provided adequate proof over and over. I try to tell people, you have to write your documentation as if a stranger will read it. It is not about how familiar you are with your first line supervisor. A stranger will have to evaluate if they believe your position. So you need to write it and not assume everything is known, because that stranger's not going to know the background. So those people did great. Pinnell needs to stop playing. Thank you, Paulette. Thank you, Miss Queen Liz. All right, y'all. Have a great, great night. Hopefully, I'll still have my voice in the morning. But this one was very interesting for me, and I'm glad y'all stuck around. All right, I'll see you later. Bye.